This is the time set for public hearing in the matter of amendments to Supreme Court Rule 79 regarding professional liability insurance for attorneys engaged in private practice. We've received a number of correspondence for and against in this matter. This is the time for public hearing. We would like to have opening remarks from the State Bar of Nevada as to this issue. Thereafter, we will allow people to speak for or against whichever their preference is. We would ask you to limit your comments and not necessarily go into great detail in terms of things that have already been stated, but you can mention them. Justice Pickering is in the South today to play host to those people who wish to appear in Las Vegas. Justice Perigary had a conflict, so he is not able to participate in this public hearing, but it has received the correspondence and will review the tape and any other additional correspondence submitted if we deem it appropriate at the conclusion of this public hearing. Mr. Library?
Chief Justice Douglas and Justices, I've been asked on behalf of the State Bar of Nevada to present support for ADKT 0534. After serious discussion and research, the Board of Governors of the State Bar of Nevada unanimously recommended to the Nevada Supreme Court to amend Supreme Court Rule 79 to require professional liability insurance for all attorneys engaged in private practice. The State Bar's mission is to govern the legal profession, serve our members, and protect public interests. This mission is fulfilled through rigorous admission standards, ethical standards, enforcement of ethical standards, client protection programs, and CLE requirements. Requiring comprehensive client protection through mandatory minimum malpractice insurance does not differ from all the other requirements of the bar as implemented by this court. Requiring a minimum level of professional liability insurance response to the mission is to put in place safeguards for both the attorneys and the client if the negligent act occurs. The proposal of minimum mandatory malpractice insurance so transparently protects both the public and the vulnerable practitioners, coupled with the overall goal of honoring our profession. This court has required $500,000 minimum professional liability insurance for those attorneys who seek specialty licensures, such as family law, personal injury, workers' compensation. The State Bar of Nevada requires professional liability insurance for private practice attorneys who accept cases to the Lawyer Referral Service, and for those who serve on the Transitioning into Practice, the TIP program, TIP mentors. The basis for requiring minimum mandatory malpractice insurance is simple and common sense. To obtain a state license, you must demonstrate that you have the ability to protect the public if anyone is injured by your negligence. Throughout this process, we considered a number of models with regard to providing malpractice insurance and determined that the open market model works best in Nevada. In fact, the Nevada Insurance Commissioner, Barbara Richardson, advised the Insurance Task Force that the current insurance market is very competitive and offers affordable policies. She recommended the open market model be utilized as it provides the most flexibility for attorneys to obtain competitive quotes and select a carrier with service and pricing that best meets their needs. The open market is what the State Supreme Court of Idaho adopted when it implemented mandatory malpractice insurance for Idaho attorneys. And that program has been successful. There have been no issues with respect to attorneys not being able to obtain malpractice insurance. The bar at this stage, at all stages in this evaluation of malpractice, heard the concerns of attorneys opposing mandatory malpractice. Those concerns fall into 6 areas. Cost, the concern with cost and having to pay for malpractice. 2, they think it's a boom for insurance companies, that insurance companies can raise rates and will control the market. 3, they say prevent pro bono work, or what they refer to, and I learned the term low bono, which is assisting people at less rates. And then it prevents older attorneys to assist friends, relatives, and others. And there's a concern about the inability to obtain insurance. And there's concern that there's a mandate what an attorney must do. Given the relatively low number of attorneys in Nevada without insurance who would seek insurance, among the numerous carriers, we have over 19 carriers providing malpractice insurance in the state of Nevada. It is very unlikely that there would be a negative impact by the implementation of mandatory malpractice insurance. In insurance, if insurers raise rates, other carriers move into the market because it's a perfect opportunity. Now, attorneys are professionals, and professionals conduct their business in complying with the highest standards. 85% of the Nevada lawyers comply and have malpractice insurance. But our mission is to protect the public, so it's vital to ensure that the current uninsured 15% carry minimum malpractice insurance. Securing insurance as a matter of doing business is commonplace for professionals, including doctors, accountants, and engineers. Prudent businessmen of all types secure insurance as a means of personal and public protection if error occurs. And with regard to our survey, with regard to all lawyers who responded, they all agree that even the best of lawyers are not immune from potential making errors, making mistakes. So even attorneys who do great work, it's great to be sued. ALPS, the state bar, has endorsed professional liability insurance carrier covers about 58% of those insured in Nevada. And they reported at our request with respect to how much they paid out in claims for the last 5 years. And it was $6.6 million. They paid out $12.8 million over the last 10 years and almost $50 million since 1998. And that data only represents ALPS and does not include claims paid by competitors in the market. Based upon information provided by ALPS, 3 to 4 malpractice claims per 100 Nevada attorneys are filed each year, equaling a claims frequency of 3.5%. Considering the roughly 1,000 uninsured attorneys in the state without insurance, and without knowing whether that community is more susceptible to claims or not, we would estimate that the uninsured attorney is being prone to about 30 to 40 claims per year. But it's impossible to point to statistics because attorneys who do not have malpractice insurance don't get sued because they don't have the assets, so lawyers don't take the cases. In fact, with regard to some of the oppositions, they've said that by having malpractice insurance, they will have bullseyes on them, right? Because they have insurance. However, to prepare for this hearing, I looked at cases that were being filed. A particular case was filed against an attorney who was suspended from the practice of law and was being sued who did not have malpractice insurance. And that attorney was being sued not only himself but his wife as a trustee. And so I called the attorney that was bringing that lawsuit, and I wanted to talk to the client. And in the course of my conversation with that new lawyer, I learned he also did not have malpractice insurance and was against mandatory malpractice insurance. I never got to talk to the client, but I thought it was interesting that a client that was damaged by an attorney without malpractice insurance doesn't even seek an attorney with insurance. However, we did focus groups, and we now know that his clients simply do not know enough to protect themselves. They're afraid to ask a lawyer if he has malpractice insurance. I served on the Client Security Fund for a number of years, and during the tenure I saw too many examples of malpractice by attorneys without insurance to protect their clients. Of the 33 claims denied by the Client Security Fund over the past 5 years, 66% denied because the claim resulted from attorney negligence or malpractice rather than theft. The Client Security Fund only covers theft. So these people are left without recourse. So I saw time and time again people injured with no recourse because their attorneys had no assets, at least visibly, for whatever reason. They couldn't get attorneys, and they were hurt. Recognizing the impact of requiring a minimum professional liability insurance policy on private practice attorneys, especially solo or small practitioners, the bar took that into consideration. But regardless of the size of the law firm, it is the responsibility to protect the clients. However, to assist with this consideration of mandatory malpractice, the State Bar asks ALPS to project pricing expectations for those without coverage. And we developed, and it was not at the suggestion of the insurance company. We had hearings with insurance companies. We initially were looking at 100, 300 coverages, which is what the state of Idaho has. And we asked the question with regard to ALPS. What is the average payout with regard to a claim? And the average payout with defense costs runs about $250,000. So minimum coverage 100 to 300 really doesn't protect the public. So we came up with the concept of 250 of insurance, basic insurance, where the defense cost comes out of the coverage. But rates, it's impossible to just come up with a rate. We did come up with a rate for $100,000 for every lawyer in the state of Nevada. We looked at that, but the problem is that cost, the $100,000, is $3,000 per lawyer. And the attorneys in the north would be subsidizing the attorneys in the south. So we looked at the open market, and the estimated premium for Washoe County, on average for the first year, taking into consideration all types of practices, and we'll go into some are much less than others, is $1,350 for Washoe County for the first year of coverage. Why? Because the first year there's no prior acts. So once you get insured, all these people that are currently uninsured now, well, they are like newborn insurers, and they get the lower premiums. They don't get the higher premiums unless they have several disciplines, a lot of malpractice claims in the past. But their coverage, if they're as good as they say they are, and they all say, we don't need the insurance because we've never been sued. If they're that good, they're going to start off with no prior acts, and their coverage is going to be less. But anyway, it's $1,350 for Washoe County, and with regard to Clark County, it's higher, it's about $1,500. Now, these rates are equivalent to about 1 hour of billable time a month. So they're a cost of doing business. Now, with regard to our survey that we took in April 2017, we found that the primary area of practice of these solo attorneys fell into 5 areas: general civil litigation, plaintiff, criminal defense, corporate, business law, personal injury, plaintiff, and family law. And with regard to 250, The premiums range with regard to those areas is between $813 to $1,500, slightly higher for Clark County. Now, the rates with regard to area of practice, for example, with regard to criminal defense, which is the least, is for Clark, for the rest of the state, not including Clark County, $655. With Clark County, it's $698. Family law is $982. For the remainder of the state, Clark is $1,047. However, that's the first year premium, and we realize that premiums increase about 15% per year to a maximum after 6 years. You get to the maximum rate after 6 years. For example, in 6 years, the average rate with regard to malpractice in Clark County would be $3,489, and with regard to the rest of the state, it would be $3,140. Now, certain risks do not fall in the standard market, and they might have to pay higher costs. However, that wasn't what was found to be in the state of Idaho. They found that their uninsured fell into the regular marketplace. But even those with difficult, they can obtain insurance. It's feasible. Everyone is insured. It's a matter of cost. And so we believe with regard to those markets, and those markets are not necessarily much higher if people have difficulty. And actually the state bar would be willing to assist those persons with difficulty and work with them to find coverage. And with regard to young lawyers, the House has a program that for new lawyers, it's $500 for the first year. Second year is $1,000, and that goes up to $1,500 for the 250. So those are basic policies. Now, one of the issues is attorneys that are semi-retired and may only represent a few selected clients. Well, actually, they're insurable and their rates are much lower. They can get insurance. Every insurance company does provide at least a 50% discount for attorneys who practice less than 25 billable hours per week. And it's even less. And I can assure you that if there's a market there, those rates will go down. I think in conclusion that requiring minimum level of professional liability insurance responds to the State Bar's mission to protect the public. And it's important to protect the public. Years ago, attorneys refused pro bono based on the argument that there was a lack of malpractice insurance. So the pro bono legal organizations went out and resolved that issue by getting malpractice insurance for all those persons that perform pro bono. And those attorneys who argue that they can't do pro bono must not be aware that they can and in fact are insured through pro bono. Because the proposed amendment only applies to those attorneys engaged, there are attorneys whom the rule would not apply. And those that are active, retired, still maintaining their license but not doing any legal work, they are exempt. Attorneys working for organizations, corporations are exempt, and those in the public sector are exempt. Now, the State Bar will require on an audit demonstration of a deck page from time to time of these to demonstrate their insurance. But based upon the focus groups, the public in Nevada must be protected, as they simply do not know how to protect themselves from the harm of negligence by their attorney. As stated by Dan Dugan, Trial Science, who conducted the focus group, in his non-lawyer opinion, it makes the uninformed consumer pray for the least competent, least ethical lawyers, the exact lawyers who should have coverage and probably the exact ones who don't. The consumer protection notion and that non-mandatory insurance reflects badly on those who have malpractice insurance demonstrates why the court should consider mandatory malpractice. Besides, mandatory malpractice insurance is just the right thing to do. It's been the right thing to do for a long time, and although many states have not done it, that doesn't mean it's not the right thing. And we ask the court to support what the Board of Governors has presented for the mandatory malpractice insurance of $250. Now, through the course of looking at some of the opposition, there are some good points that are being made. And, for example, why should pro hoc attorneys not be required to have mandatory malpractice? It's a good concept. There's other concepts that are presented with regard to those attorneys that only do private practice, but they only engage in services with regard to state and city governments. So they are not practicing in the general public. There are some good concepts. But we believe that, as drafted, this concept with regard to mandatory malpractice is a good concept. It's modeled after the state of Idaho. And we believe that in time, we can refine it even more. You have to start somewhere. So we ask the court to start with the mandatory malpractice.
Chief, I have a question for Mr. Leverty. Could you look at Exhibit A of the submission with the petition, which I believe is Exhibit A, which is, I believe, the proposed rule?
Is that with regard to
Exhibit A is Rule 79.
Yes, I have it.
With the applicable edits.
Look at what?
Do you have that in front of you?
I do, Your Honor.
Okay. I have two questions.
Okay.
And they both relate to paragraph 3 of the rule.
Okay.
As edited. The first is the term private practice of law a defined term anywhere in our rules? And or, second part of that question, are the exceptions to the requirement to maintain insurance, as you mentioned earlier, government attorneys, some others, spelled out somewhere in the rule? I don't see that in the submission that we have, and perhaps that generates some issues from those who've commented. So is it the intention of the Board of Governors vote that some lawyers admitted to practice in our state would not be subject to the requirement to maintain professional malpractice? And if so, where are those exceptions spelled out?
Your Honor, I can't answer with regard to the definition of private practice. I don't see it in Rule 79. Mm-hmm. But as private practice, it was the intent that private practice is those who are engaged in representing clients and not corporations, working solely for corporations. So the exemptions that I set forth.
So that's why I wanted some clarification, Mr. Leverty, because, for example, would in-house corporate counsel be required to have malpractice insurance? It would seem the underlying purpose behind the bar's recommendation wouldn't require that. But it's not. Yeah, so I'm just thinking, Mr. Leverty, at least it would be of assistance to me. I don't know about other members of the court. But if there are exceptions, it seems like a little work needs to be done on Exhibit A to make clear what exceptions the Board of Governors in their vote on this thought was appropriate.
I agree.
So if we were to enter an order and just attach Exhibit A, I can see confusion right out of the box that corporate counsel, for example, or legal aid lawyers, for example, I don't know who would be in that group. So I'm interested in knowing what was the list of categories of lawyers that the bar said would not be required to meet this requirement.
That's a good point.
I've got some questions. First of all, I've been there and done that with you with the Client Security Fund, and I remember, because we both served on it for a long time, the most egregious claims were malpractice, and we had to say no to the people. It was very sad because the Client Security Fund does not pay when there's malpractice, and the people, if the attorney did not have assets or insurance, they were out of luck, and it was sad. So you're absolutely right on that. My question is, I think you guys did a great job in putting this together for us as far as rates. What bothers me is all the major law firms that are in town now. I mean, major national, international law firms. And I think that that should have an effect on the pricing, especially for a medium-sized law firm like Bob Edwards' firm, or maybe a sole practitioner or a small partnership, where they get the advantage of being practicing law in the state of Nevada, along with competition from a major law firm that's in 18 cities. So was that taken into account at all, Mr. Leverty?
What you're saying is, will the rates go down because of that?
Yeah, shouldn't they? Should they? It's not even will they, shouldn't they go down?
You know, it depends on the individual companies and their experience. A lot of those large insurers, those large law firms are insured with Lloyd's because they have higher limits, they have multi-million-dollar limits. So I think that the overall experience of malpractice in Nevada goes into the rate making. So regardless of whether you're a large law firm or a small law firm, it goes into the rates.
What about mediators? Are we going to have our mediators, especially those who have small private practices also?
Yeah, that's a good point. And I looked at, there was a lot of projections, including Noam Manukian. He was listed as one of those projected. And so I called. And his concern was with regard to who does mediation, with regard to the court. And, you know, so I called the insurance carrier. I said, you know, what would it cost for a mediator to get insurance? He said, not much. They don't have any exposure. So that's never been presented. But I think that that would be an easy area to cover. Now, if they're solely mediating, the rate should be reasonable. However, I saw some that said they primarily mediate, which indicates they may have some other exposure. So based on potentially other exposure, the rates may be higher. But I think mediation definitely should not be an issue, because I think a carrier accept risk where hopefully they don't have to pay out.
Yeah, I found that amazing, to tell you the truth, now that I've been looking at various mediation services, the number of private attorneys who have practices in major law firms are mediators. And I took one on who was doing construction defect. He's a construction defect lawyer, and he's a mediator for jams. And I just wonder how that works for somebody who's still doing private practice and mediation. And I don't know, does the insurance company determine the amount of time of mediation and amount of time that he's the managing partner of a major law firm? There's a couple like that, a number of them like that.
Yeah, probably what they do with regard to rate making with regard to a major firm is they take all the areas of practice and then they come up with the rate. Mm-hmm. So some are going to be higher, some will be less, and they do the average and they come up with it.
Well, I do want to congratulate the State Bar for being persistent on this issue, and I would say, as somebody who's been here for 48 years and on the bench now for 20 years, that times are changing. So congratulations on trying this. Hopefully my colleagues will be.
Any other questions? Justice Gibbons?
Yes, Mr. Riley. First of all, I thought you were paroled last week in Chicago from having come down and make these presentations. But thank you for doing it. It was an excellent presentation. I think everything you covered answered a lot of my questions. My concern is this. We've received quite a few letters and comments opposed to it from the firms you categorized in your presentation. When the Board of Governors met to discuss this, was it discussed that this is kind of analogous to being a member of the State Bar of Nevada? I mean, you can't opt out. If you practice here, you must be a member. You must pay your annual dues and do that. And also, car insurance. I mean, if you want to drive, it's mandatory to have liability insurance. And I know the limits have been recently raised on that. So how is practicing law any different than some of these? Is it something that's just adjunct to being a member of the State Bar, just something you need to do? Was that part of the calculus in your recommendations?
Absolutely. That's what it is. It boils down to. There was a belief in the public, we believe, to focus group. They assumed that lawyers had malpractice. In fact, some of them do. But some very intelligent don't understand that malpractice and how to approach a lawyer and have disclosure, because they're afraid to even ask the lawyer if that's malpractice insurance, because they're afraid that their lawyer may think that they're trying to sue. But the answer with regard to, yes, if there's a belief that attorneys have malpractice insurance, just like everyone's required to have auto insurance. You know, and lawyers love everybody else to have malpractice insurance. They are the proponents, and yet we don't require it of our own profession. And who suffers? All the lawyers without malpractice insurance hurt all lawyers' profession. You know, we are all with the same brush stroke with regard to when they hear a problem and somebody gets hurt. And too many people are getting hurt with regard to that. So we need to stop that. It's the right thing to do. Thank you.
Chief, I have one more question.
Mr. Sarsi, please.
When I was practicing, Mr. Leverty, one of the questions on the annual renewal form was whether or not you were the subject of or had knowledge of a complaint, professional complaint, lodged against you with the state bar. And I was always advised, not that I ever had to answer yes, but the concern I had was that seemed to be a factor in the rate determination for subsequent periods, because these are claims-made policies. It has always seemed to me to be unfair that an insurance company would rate a lawyer simply because they answer that question yes, provide an explanation. It's a frivolous complaint that's been lodged by a client or a former client, or maybe even somebody else. And there's been no disposition. We've had although the bar has done a remarkable job of updating the status of discipline cases, and hopefully the Supreme Court has been on top of getting those final dispositions, there can be a fair delay between the point in time when there's a complaint and a disposition. So what troubles me is that insurance companies would rate a lawyer or increase their rates on a policy simply because they respond that they have knowledge of a complaint having been filed, even though it's deemed to be frivolous or meritless. Was that issue explored with ALPS or any of the other insurance companies that you consulted with? And if not, I'd be interested in knowing what the bar thinks of a provision that's included in the rule that as part of any subsequent rate making, that any rates can only be assessed based upon the outcome of discipline cases, not based upon the complaints.
I think it's a good idea. I'm not sure what the insurance company used to increase rates. I don't even know if it's on the application. I know annually you have to fill out the application. You have to tell the areas of practice, potential claims. Those have regard to potentially in the future. But with regard to whether or not you have a discipline man, I don't know. But, the rate making is an issue with that insurance. Okay, rates have to be filed. They're approved. We could put it in our rule. We could argue with regard to those companies, especially those that are going to be sponsored by the state bar, because we do sponsor malpractice carriers. So we can make it a rule of the state bar that we simply won't sponsor an insurance company that uses discipline or just discipline and not determinations on discipline in its rate. And I think that would solve the issue.
Thank you.
Any other questions?
Justice Douglas and Jean Leverty, I have a question from Las Vegas. In fact, I have a few. One, our existing rule currently requires a lawyer to disclose to the bar whether he or she has insurance and to provide the name of the carrier. What has the bar ever done with those mandatory disclosures by lawyers?
Justice Pickering, we have utilized that information with regard to this task force. That's how we arrived at the 15% that are currently uninsured. We also gathered from that the 19 carriers that currently write in the state of Nevada. However, that information is not available to the public, and it's not verified by the state bar. We don't verify that the carrier that is listed by the attorney is in fact providing coverage. So with respect, Nevada, we're one of the fortunate states because I have testified on this issue both in the state of Washington and California. California does not have any statistics as to the amount of people uninsured or the coverages, but Washington does. So it makes a lot of difference in how you approach this issue, because both of them, California is being dictated by the legislature, you can strongly consider requiring mandatory malpractice insurance. So to answer your question, the answer.
So you're not. But you're not doing any, the information on existing Rule 79 says the information submitted under this rule shall be non-confidential. So right now we are a state that mandates that lawyers disclose to the state bar whether they're insured or not. And the rule says it's non-confidential. But as I understand the answer to your question, you don't disclose that anywhere to the public as to whether a given lawyer does or does not have malpractice insurance.
With regard to the website for the state bar, it's my understanding, and I could be wrong, and I'm sure Kim Farmer, who's in Las Vegas, will correct me. It's my understanding that we do not list it on our under the lawyers whether or not specifically what malpractice carrier they have, and we certainly don't know the limits of their coverage.
But you don't even, is there any way a person who's a consumer of legal services can get this information currently, whether somebody's insured or not?
I can't answer that. I don't believe that they can.
Okay. Secondly, I just want to confirm for the record that only 2 states currently mandate malpractice insurance for lawyers. The first is Oregon, which has done so for some number of years, and the second is Idaho, which imposed that requirement effective January of 2018. Is that correct?
There's actually a third state, the state of Illinois, as mandatory.
That mandates mandatory insurance?
Yes. But if you don't have it, you have to take a loss control course each and every year that you don't have it. So there's mandatory CLE requirements.
But it's not a condition of your license in Illinois that you have it. They have a saving clause that you can take some alternative training and avoid that requirement. Is that right?
That's right. But I also had the pleasure of listening to the program director for Illinois, and what they are doing is gathering statistics so they can go the next step of mandatory. So they didn't have the statistical information as to the number of insured and uninsured, so they're hopeful to gather it through this process.
And has the American Bar Association taken a position on whether or not state bars should be mandating that lawyers carry malpractice insurance?
To my knowledge, it has not.
Under this rule, if a lawyer is insured, and when you first sign up for insurance, if it's claims made, you have no history, so your rates, although you're inexperienced, will be lower than they will as you move forward and you've acquired a history of handled matters for clients in the past. That's fair, right? They go up over time?
Well, they go up in time because you're insured for a longer period of time, along with the
expense. What if a small firm has had no claims, but the rates going up over time place that firm in a position where economically it can't afford it? Or the insurance company goes out of business and stops writing in Nevada and they can't get substitute coverage. There's a variety of ways that this could happen. This rule, as I understand it, puts that lawyer out of business if that lawyer is not able to get insurance. Is that correct?
That is correct. But there's also...
And there's no grace period or...
There is. I was going to say, there is a grace period. They have the opportunity to find other coverage.
They have 30 days, right?
I believe so.
Is there information in the presentation that addresses what a small firm's likely premium cost would be for this 250 after 10 or 20 years of practice doing general civil litigation and family law?
Your Honor, it tops out after 6 years, and I gave the premium rate with regard to our discussion. With regard to both Las Vegas, the maximum rate would be about $3,500 after 6. That's actually Clark County is $3,489, and the rest of the states $3,140 would be the top rate after 6 years.
And that's
so
per
even
lawyer.
If it's 10 years, that would be the rate.
So that's per lawyer? So a two-person
Per
shop
lawyer.
would be $7,000?
Yes, but rates go down based on the number of lawyers. That's another factor.
Right, right. Okay, thank you.
Thank you. Thank you all.
If we have another speaker in Carson City.
New Chief Justice of the Court. My name is Robert Eglett, and I'm here today to offer support for ADKT 534. Practicing law in the state of Nevada is a privilege, not a right. And I believe as attorneys, we have not only an ethical, but a moral obligation to our clients and the public to ensure that any harm caused to them by us or any member of our state bar does not go unmitigated. We expect our clients to put their trust in us to serve their best interest. How can we credibly expect them to do this while at the same time we are not doing everything possible to protect them from harm that can be caused by us? Lawyers, just like all professionals and all people, are not infallible. We make mistakes, and we will continue to do so. But when those mistakes rise to the level of negligence or worse, and cause harm to the consumers of our legal services, it is incumbent upon us to mitigate that harm as much as possible. State law mandates most professionals to carry professional liability insurance. These laws were passed in order to protect the public from harm caused by those professions. For example, our medical profession has an all-encompassing malpractice insurance statute that requires healthcare providers to maintain professional liability insurance. And just a sampling of some of the other occupations that our state law requires to carry liability insurance include asset managers, contractors, debt managers, energy auditors, exchange facilitators, financial planners, inspectors, private investigators, private patrol officers, process servers, polygraph examiners, reprocessors, cable TV companies, ambulance services, pest controllers, and dog handlers. Yet attorneys are exempt from this requirement in our state. Now, why do we, as a profession that governs our own members, allow this to happen? Professional liability insurance is important to professionals and clients alike. Many professionals, whether prestigious or not, come with the risk of harming the clients they serve, and to that end, most states have numerous professional liability statutes in place. Lawyers should not be the exception. Therefore, I urge this court to adopt the amendment proposed in ADKT 534 requiring mandatory professional liability insurance for attorneys in private practice. I guess I'm on a time limit.
We're trying to keep this in
Okay,
check because.
very good. If there's I'll stop here then unless there's any questions.
Mr. Eglett, you heard my questions, I presume, to Mr. Leverty about certain members of the practice for whom insurance would not be expected. At least I understood him to say that. Do you share that view? And have you I know you've been participating in this subject in a number of meetings and the like. Has there been a list compiled?
Yes, and I do support the exceptions. As Your Honor, Justice Hardesty knows, I started this quest 3 years ago with a lunch I had with you where I brought this subject up and then later talked to Justice Cherry and Justice Gibbons about this, and I'm very proud of the State Bar's actions they've taken in pursuing this. And so, yes, I suggested when I first presented this to the time Brian Scott, former State Bar President, that there be some carve-outs. I, at the time, suggested maybe there should be some carve-outs for lawyers who only specialize in criminal defense work. That didn't happen, but that's the decision they made. And I also agree with the carve-outs for pro bono lawyers, legal aid lawyers. I think that there probably should be an exception for those lawyers as well, and maybe an exception for lawyers that are, over the age of 70 or something that are retired. And I know there's somebody here from the state with respect to lawyers who only do contract work for government entities, that maybe there should be a carve-out for them as well. And I don't have any problem. I would only say that if there are carve-outs or if this court were inclined for any reason not to support the State Bar's position on this, that at a minimum, what I also requested from the State Bar and in an open letter I sent to all of you a year ago, that at a minimum there should be a client disclosure in bold print up front in retainer agreements that every client signs, and we're required ethically to go through those retainer agreements with them and explain them to them, telling the client that the lawyer does not carry malpractice insurance. And 7 states require that now. And there's one of the primary reasons they cite for requiring that. The number one reason they cite is whether an attorney has malpractice insurance is a material fact clients should know when making their decision on who will represent them.
Do those states, I'm sorry to interrupt you from Las Vegas, but do those states that, do you know which states they are off the top of your head?
Yes. They are
Or in your
Alaska, California, thank you, Justice Pickering, Alaska, California, New Hampshire, New Mexico, Ohio, Pennsylvania, and South Dakota require disclosure directly to the clients in the field.
And do they back that up with anything that's available through the State Bar, or is that's in addition to whatever public disclosures may be when someone's shopping for a lawyer? Or do you know?
My understanding is that these states require the attorneys to disclose to a client before they sign them up in the fee agreement that they're bare. They don't have malpractice insurance. If they do.
Right, but is there any backup that, in addition to that, which makes sense to me, that makes sense as a disclosure, and I remember your letter on that point. But is there any support from the State Bar in those states that you know of that lists the lawyers who are bare or not carrying malpractice insurance?
That I don't know, Justice Pickering.
Okay, thank you.
I just hope that the State Bar is tough on some of the insurance companies, because what you've done your whole career is go against insurance companies, and I did for a while. And I also did some special master work where I had to cooperate, make sure the plaintiffs and the insurance companies played fair with each other. What I worry about is maybe all of a sudden some of the law firms may decide that they'll do what the hospitals did and say that the doctors are independent contractors or the lawyers are independent contractors, or that a firm like yours, you trust your associates and maybe, and I use you as an example, Bob, it's just easier because you're here, a couple statutes run where you have to pay out some money because statute of limitations run on a PI case.
Right.
I mean, are they going to then nail the other firm for a couple of things where they had to come up with some money? I mean, that's what I worry about, to Gene and to you, about that they, and what Chris brought up, what Justice Pickering brought up about pricing a firm like yours, a medium-sized, I call yours a medium-sized firm, well, it's a major firm in this state, price you out of the market with malpractice insurance.
Well,
worry about that.
We already currently pay hundreds of thousands of dollars a year in malpractice insurance because of the level of coverage we carry because of the type of cases we're doing. So, you know, this isn't going to financially affect my firm whatsoever. We have an umbrella policy with Lloyd's of London that's huge because we need to because of the nature of the case.
I just worry about some of the other folks, especially some of the advertisers who are advertising, there's so many of them in Las Vegas, now Reno. And I assume in the rules also, just want to make sure that the lawyers get a fair shake from the insurance companies on this. That's what I worry
Well,
about.
and I always share the same concern, Justice Cherry, when it comes to getting a fair shake for insurance companies. But I would just say, lawyers have a lot of money to advertise on TV. They certainly have money to pay for a $250,000 minimum policy to protect their clients.
Justice Hardesty. Yes, Mr. Roberts.
I had one other issue. Do you know if carriers require disclosure of any facts or discipline complaints, even if the discipline complaints are pending and not resolved?
The application I have to fill out every year is like 50 pages long, and I am sure that there are, and I have to do it for each lawyer in my office, I am sure that there are requirements. This is going off memory because I usually do this in January, Justice Hardesty. I believe there is a requirement that we disclose any state bar complaints.
I'm assuming, but I don't know if you know, is that factored into the rate for the upcoming year?
I'm very tough at negotiating with our insurance carriers about the coverage. I don't know whether they initially try to do that, but my experience is because we haven't had a claim in decades that our insurance rates go down. And have been going down. But we carry a lot of insurance, and we have 14 lawyers, so that makes it difficult.
Would you be satisfied if the rate, if the coverage was 100, 300, rather than the 250?
No, and this is why, Justice Cherry, I personally wish it was $1 million because most lawyers that I know who carry malpractice insurance carry a minimum of $1 million. And I don't think, quite frankly, there's all that much difference between a 250 policy and a $1 million policy in my experience because something like 95% of malpractice claims are resolved for $250,000 or less. So to buy that extra coverage doesn't cost very much. So the problem is if you go under 250, then you're going to start losing, portions of claims that aren't covered because it's not enough money to cover the claim.
Closing thought.
Thank you very much for Chief Justice and members of the court for hearing this issue. I think it's important for the entire bar and certainly for the community that we represent.
Thank you. Do we have anyone else in Carson City who wishes to come forward?
Thank you, Your Honors. For the record, Kevin Powers, Chief Litigation Counsel, LCB Legal Division, appearing today on behalf of the Legislative Counsel Bureau, or LCB. We have submitted written comments asking the court to consider an exemption for those lawyers who do not represent the public at all. They're private practice attorneys. They do not represent the public at all, but they represent only state and local government agencies and officers and employees in matters relating to their public functions. Since they don't represent members of the public at all, we don't believe this malpractice insurance would be beneficial because the state agencies or the local agencies are the clients, and it's highly unlikely that they'll be looking to these attorneys for malpractice claims. And so there would not be a benefit to the public. In exchange, there would be a detriment to the local and state agencies because they'd have to pay more for these private practice attorneys. Now, if the court didn't think this exemption was appropriate because it was too broad, then the LCB would argue that the court should consider exemption at least for private practice attorneys who contract with the LCB and provide legal services exclusively in the state legislative branch. During each legislative session, the LCB will contract with private practice attorneys. Typically, they have been former employees of the LCB, but they also have been former employees of government agencies. We contract with them. They provide legal services exclusively in the state legislative branch, and we don't believe it would be appropriate to require them to have malpractice insurance under this proposal. And we believe that as a matter of separation of powers, that has to be done because obviously the legislature has its own inherent and constitutional powers to control its own proceedings, so it would have the right to have its agencies contract with private attorneys to provide legal services exclusively in the legislative branch. The LCB also shares Justice Hardesty's drafting concerns with the proposal as drafted. Because this would be a substantive rule, the LCB contends that these provisions shouldn't be included in Rule 79 relating to disclosures, but it should be its own separate Supreme Court rule, presumably Rule 78.7. And the rule should be set up that subsection 1 should state the general requirement. Subsection 2 should state very specifically and clearly the exemptions from the general requirement, and subsection 3 then could provide for the enforcement mechanism, which suggested here would be random audits to determine proof of compliance. Then Rule 79 could use a cross-reference to that new rule to include a disclosure at each annual license renewal to make sure the attorneys are disclosing that they're complying with the malpractice requirement or are exempt from the malpractice requirement. To answer Justice Hardy's question, the term private practice law is not defined in the Supreme Court rules. I would say, too, Rule 79 right now, obviously every member has to make disclosures, and the disclosures list whether you're a full-time government employee or a judge, you're employed by an organization of clients. These are fine for disclosures, but these need to be drafted more clearly and more specifically if they're going to be exemptions. For example, even with regard to the full-time government lawyer or judge, NRS 7.065 authorizes public attorneys employed by the state or local government to provide pro bono representation through a legal service agency. So even in that circumstance, you have an attorney who would be exempt in their government role but potentially subject to it when they're providing pro bono services. So, of course, the LCB supports making sure that that attorney, the public attorney, can still provide those pro bono services.
In that case, though, the pro bono providers are providing the insurance coverage that they come on under presently.
And that would work, but I think the rule and the exceptions to make it clear that you're accepted from the requirement if you provide pro bono services from a legal service agency that has its own malpractice insurance.
Do you have a ballpark figure as to how many attorneys you're talking about as far as if that would be part of the 15% or is it part of the 85%?
I really couldn't give you a ballpark figure. The LCB itself during legislative session could have anywhere from 1 to 5 contract attorneys who provide services exclusively for the legislative branch. But obviously there's going to be other attorneys who represent like the regulatory boards. Some of the smaller regulatory boards, like the boards of athletic trainers, boards who regulate some of the smaller professions, they contract with attorneys to provide their legal representation. They don't have employed attorneys because they don't have the sort of revenue to pay for an in-house public attorney.
So you're talking about an example like, I don't know if he still does, but John Hunt represented the medical or the dental board for umpteen years through a contract. You're talking about that individual.
That type of individual, as long as that individual is only exclusively representing state and local government agencies and office employees. If they want to represent private clients at the same time, and malpractice insurance is a requirement, then they would have to meet that.
Do you know Mr. Powers, and I don't know whether Mr. Leverty knows or other members of the bar who are here, but my memory of policies that I used to maintain, there were carve-outs. So not only with respect to practice, but there were carve-outs for practice areas. So if Hardesty decides to start practicing in the securities area, I was told by the insurance company, good luck, buddy. and good luck to your clients. So I presume that there are carve-outs in practice areas as well.
I think that's certainly something the court needs to take into consideration, and once again, needs to be clearly expressed in an exemption subsection in a separate rule.
So like in my hypothetical with Mr. Hunt, he could potentially have a carve-out from his policy, assuming he maintained one, related to his representation of the medical board. That would fit your argument.
Correct. And I would assume most private insurance companies would not want to provide malpractice insurance to an attorney who represents a state or local agency. It would be hard for me to see the insurance company come as a premium, a way to gauge that.
Mr. Powers, are those lawyers covered under the, I haven't looked this up yet, but are those lawyers covered under the state's immunity statute?
In most circumstances, they could claim the state's immunity, yes, because if they're acting on behalf of the state, then they would. The state immunity statute in Chapter 41 does talk about certain independent contractors providing services to the state. It would depend, I would suspect, on the facts of the circumstances. Mm-hmm. And then the final thing, the LCB certainly would offer its drafting services to work with the state bar on reforming any proposal that they want to resubmit to the court with regard to how to organize the rule and better express the exceptions. Thank you.
On a lighter note, Justice Douglas and I would like to know where you apply for these jobs.
I know you're retiring. A session's coming up. We're always looking for good drafters.
Hear that, right?
I thank you for the comments, and you're on the public record as offering assistance to the state bar. With that, do we have anyone else in Carson City who wishes to be heard this time? Mr. Newman.
Chief Justice and members of the court, my name is Peter Newman. I've been a lawyer, I think, for 52 years. I'm retired. I practiced for 50 years as a trial lawyer, and I always had malpractice insurance. And I was always a sole practitioner. And I always felt, and as I do now, and I support this petition, that it's a breach of trust for the legal profession not to have insurance. If you can't trust your lawyer, who can you trust? And if a client, and I've seen some examples of this over the course of my practice, where lawyers did make a bad mistake and the client suffered harm, and the lawyer was not insured and did not have the assets to cover the harm. And I'm just thinking, what a terrible blot on the legal profession that kind of a case makes. Because that harmed client is not only going to tell his or her immediate family about how they got, you know what, by this lawyer, but they're going to tell everybody that will listen. And that is a multiplier that tends to really damage the legal profession. Because when someone is harmed, but at least gets compensation for it, that's one thing. But if they're harmed by their lawyer and they don't get any compensation at all, that's quite another thing too. The other thing I want to point out is I had at the Chicago Bar Convention, I was talking to a lawyer about this, and this lawyer was concerned about tail coverage, what happens when you retire. I can only answer from my own experience. I've been insured with ALPS for a long, long time. And I never had any claims, so when I retired, ALPS just said, well, you're covered for the same amount of coverage that you had, which is a fairly high limit, for the rest of your life, as long as you don't go out and practice law again. If you do go out and practice law, let us know, because we'll have to make some other arrangements. So I thought that was pretty reasonable. So I know there's the devil's in the details on all of these things, as Justice Harsey has demonstrated. But I think that we can come up with some language that will work, and I think it would really be great if Nevada were one of the leaders in the nation on requiring at least a minimum limits policy. $250,000 is really minimum coverage, as Justice Gibbons pointed out. If you drive a car, you have to have insurance, and I think practicing law has got every bit as much potential for harm as driving a car, and maybe in a different way, but people's lives really can be ruined by this, and I've seen that. So I really support Mr. Leverty's petition, and I'm proud of the bar for advancement.
Thank you very much. Anyone else in Carson City? Las Vegas, Justice Pickering, do you have anyone who wishes to come forward?
I think we do. We have people who signed up that indicated they wanted to speak. And some indicated maybe.
I'm one of the maybes. So, good afternoon, Your Honors. My name is Crystal Kemp. I am currently General Counsel for Solace Holdings, and it's my pleasure to serve as the President of ACC for the Nevada chapter. ACC is the Association of Corporate Counsel, and I believe the issue has been raised, but I just wanted to reiterate our concern as in-house counsel. We currently have roughly 160 members, and that doesn't include all of the in-house counsel in Nevada, but it's certainly a substantial number. So, as it's already been mentioned here, we do not hold our services out to the public, right? In addition to that, we do have other insurance coverages, right? And as far as I know, I had our global organization do the research. They found that there are no states that currently require in-house counsel to maintain malpractice insurance. So at this point, I found that my colleague from LCB's proposed separate rule and structure of same appears to address the issue that was raised by Justice Hardesty on the exemptions, and we would be supportive of that as well. So we would just appreciate it if this court would consider that all in-house counsel should be exempted.
Thank you.
Thank you. Any questions?
Any question? No questions in Carson City. Thank you.
Thank you.
None. Thank you. Please come forward.
Dirk Ravenholtz. I'd like to speak on this issue. I'm going to be the odd man out on this issue in that I think we should exhibit judicial restraint with regards to this insurance question. As the learned Robert Egglet pointed out, the state of Nevada's legislature has taken full reign of insurance on professions in the state of Nevada. And it seems to me that this is a legislative question of whether or not lawyers should have insurance or not. And so I ask that you consider the fact that if the state legislature feels it's that severe of a problem, let them take the issue on and pass the statute. And then you as the judiciary will enforce the statute as your obligations are. Second of all, I'm a little bit concerned with the rule change that we have listed here. It completely eliminates the Supreme Court in the disbarment of the attorney for not paying for insurance. It puts it exclusively in the bar's position. If you note in the actual strikeouts, the Supreme Court is eliminated from that paragraph. And I find that concerning. It's the Supreme Court that handles the legal profession in the state of Nevada, not the state bar. They do so under your guidance. And I'll note that they were subject to a 150 suspension order upon the Board of Governors and or the Supreme Court in the original rule. In the secondary rule, it's only assessed a $200 fine, and it has 30 days to answer to the state bar. I ask that you don't remove the Supreme Court from the rules, when in fact it's the Supreme Court that's supposed to monitor this profession. Finally, the $200 that's assessed. I find that interesting that it goes to the state bar. Yet, in other rules that we have, the $25 initial fee we pay to the state of Nevada for our license, NRS 7.030, the $25 goes to the Supreme Courts and then is returned over to the state fund. I don't see any reason to be funding the state bar with disciplinary actions of license questions. That's clearly the Supreme Court's issue, and that money shouldn't benefit the state bar, who apparently with the insurance company, want to get 100% coverage. And I agree that malpractice should be raised and it should be an issue that's brought up before the legislature. But I don't think the Supreme Court at this time should jump into this where all we're arguing now is exceptions to the rule. It says all lawyers. Why don't all lawyers have to pay it? Negligence isn't limited to private practice lawyers. Negligence is, in fact, the number one bar complaint or the number one issue with insurance companies is corporate law and business law. So I put it to the Supreme Court that if you're going to make every lawyer pay an X number of money to a third-party company, which I think is outside of the parameters of what this court should be doing, it expands your parameters a little too far. We're now negotiating contracts with third-party and forcing our attorneys to buy these contracts. It has nothing to do with the actual profession of law inside the courtroom. Yes, every lawyer, as Egla pointed out, every lawyer could be negligent. Well, then every lawyer should have to pay malpractice insurance. It should be universal. And I know I'm on the other side of the fence here, but I think that the Supreme Court should use judicial restraint and leave it to the legislature to give us guidance that you can then enforce the statutes.
Thank you. I don't know if any of my colleagues in Carson City have questions.
No. Thank you very much for listening to me.
Thank you, sir. Is there anyone else who wishes to speak here? Please come forward.
Justices, Mike Warhola here. I want to thank you for allowing me to speak today. I'm probably not going to be quite as polished as all of the fine people that have spoken before me today, but I just wanted to be heard on this issue. As you know, I have a number of cases that where I represent people at the State Bar of Nevada. And one of my concerns is if someone was disciplined, and let's say the Supreme Court, in its wisdom, determines that a reprimand or a suspension of some sort, whether it's a 30-day suspension or a 6-month suspension, is appropriate for the conduct or misconduct for which that attorney was accused and charged and tried. If that discipline is a disqualifying factor to obtaining insurance, then really the discipline meted out by the Supreme Court becomes essentially useless, because that attorney will no longer be able to obtain insurance based on that discipline and will suddenly find him or herself in a situation where he or she is de facto disbarred by a third party who's not even of this court. I guess my concern is there's really no limitations on insurance companies with this rule proposal whatsoever. They can raise the rates to whatever they want. They can deny coverage. There's only so many that afford coverage. I have coverage, by the way. I've had it for years. I don't pay hundred thousands of dollars a year for it. I pay about $5,000 a year, but I've had it, and I believe I should have it. But my concern is, at what point does it become a de facto disbarment situation? And I think that's, and I've talked to other colleagues of mine, and they have insurance as well, and they have that same concern. And also, we don't know how many claims it'll take. And even if they're not claims that are valid, even if they go to trial and they're defensed, how many claims will it take before all the insurance companies will stop insuring that particular attorney? Another consideration is I just renewed my policy recently. One of the things they asked for is, have you had any other claims? Have you ever been declined by any other insurance company? Do you have any potential, do you have discipline? Do you have discipline? Do you have any state bar complaints? There's a lot of good lawyers, especially, what I do a lot of family law, and there's a lot of contention in family law cases. And there's a lot of bar complaints in family law cases. I represent attorneys at the bar who have family law case matters. And my concern is that if they're predicating, or if their licensure status is predicated on claims that are filed with the state bar that go nowhere, but they can't practice because they've never been disciplined and they've never had a claim made to an insurance company, that just seems that the right to practice law is being taken away from them. And that's the concern I have, and a number of attorneys that I spoke with have. And that's all I just want to say. I want to thank you for hearing me on this.
Yeah, I want to thank you for attending.
I had one other footnote to that. Another thing that I would suggest is make it a mitigating factor under Supreme Court Rule 102.5. Make it a mitigating factor. Say if you have insurance, whether or not the insurance ties into the discipline, we're going to call that a mitigating factor. I mean, if character and reputation is a mitigating factor, it seems to me that certainly having insurance on your own volition to ensure that if you have any errors or omissions, that it's covered, should be a mitigating factor. That would create an incentive. And I like the idea, I think it's a great idea, of requiring attorneys to disclose in big bold print on the first page of their agreement with the attorney. And that's the other thing. Require attorneys to have fee agreements in Nevada. They don't always have to have fee agreements, and not all attorneys use fee agreements, but require them to have fee agreements, make them disclose out front that either they do or don't have insurance, and let the market decide what attorney they're going to go to. Let the market decide that. So with that, I'm concluding. I really appreciate you hearing me.
Thank you. I don't know if anyone in Carson City has questions.
I do. Thank you for your input, and your suggestions and your comments are very helpful. But I'm concerned about what the statistics and the facts are, and maybe you could help the court in its deliberation on this point. Do you know of the 19 providers in the state, whether how they handle disciplined lawyers with respect to insurance or reinsurance? I don't think you're suggesting, or maybe you know, that a lawyer who has had a 30-day suspension or a 6-month suspension is uninsurable. Now, I get the economics. That's an issue that I am hopeful we'll get some additional information from the bar about. But I would like to know whether it is the case that there would be a de facto disbarment by anyone who is disciplined for 30 days or a public reprimand or 6 months resulting from this. I'll compare this to another circumstance. If someone fails to take their CLE, our rules currently say that you are administratively suspended. Does that mean that that lawyer, and I know there's a lot of lawyers, including very prominent lawyers, who I suspect have malpractice insurance, I doubt that their CLE suspension has prevented them from securing malpractice insurance. So it would be helpful to know whether we're dealing with speculation or whether we're dealing with facts. And I know that requires some information from insurance companies, but maybe you have some sources, whether it be colleagues or others in the profession or clients, that could offer some input on this point. If you could follow up, that would be of use.
Justice Hardesty, I have no information on that, quite frankly. The only information I have is my own experience. And every application that I've ever filled out for malpractice insurance asks me if I've ever been disciplined.
Right, but there's a difference between rating and pricing and being uninsurable. And that's a major issue here. Now, I recognize, I suppose, under certain circumstances, that a lawyer's discipline could render them completely uninsurable. But we've had a number of suspensions here for as long as 4 years for felonies. Are those lawyers uninsurable? I'd be interested in knowing that. Because they come back, they have a right under our rules to seek reinstatement. So when they petition for reinstatement, are the insurance companies treating them as uninsurable? We need to know that. I mean, I could cite a number of examples, but I don't think that's necessary. So I think that this is important information for the court to consider.
Yes, sir, Your Honor. I wish I had more information. I received notice of this I think it was mid last week, so I didn't have an opportunity to really look into it.
Sure. Well, thanks for your participation today.
Yeah, thank you, Justices, for hearing me. Thank you.
Is there anyone else? Yes, we have another gentleman.
Good afternoon, Justices. My name is Barney Ailes. I've been practicing law here in Clark County for 35 years. I'm sort of getting into more of a downward part-time position. So my concern is there's only a few states apparently that have thought to broach this issue. I don't know that there's really a public need issue that I see. I think there's maybe the law of unintended consequences could kick in here because, we talked about and we heard about mandatory automobile liability insurance. And that has spawned a lot of advertising that I find somewhat objectionable, just from just my professional viewpoint. So I see that we have another aspect of mandatory insurance could lead to some very awkward advertising that I see that would be demeaning to the profession. So those are my comments on that. And one, I would see and would like to see some kind of a carve out for part-time attorneys. And I'd like to see that the insurance would have to be approved by the state bar, so then they may be able to control how these private insurance companies are going to write policies and perhaps prohibit attorneys from being able to get this mandatory insurance. And that's basically all I have to say. Unless there's
Thank
any
you.
questions.
Just wait a moment. I don't know if anyone in Carson City has questions.
There's no questions. Thank you.
Thank you, Your Honor.
Thank you, sir. Is there anyone else who wishes to speak here in Las Vegas? It looks like we're done here, Justice Douglas.
Okay. The comments that have been provided this day have been very helpful. I would ask my colleagues if they wish to open this matter for additional time for additional comments, or if they want to discuss the matters that have been provided this date, and then issue a statement as to a call for additional information or ask for more pointed information from the State Bar of Nevada.
I've got a question in that area, Chief.
Go ahead.
I want to know, Gene and Kevin, very informal I'm saying to you, how would you coordinate your efforts with LCB and with the State Bar, Kevin and Gene? Because it sounds like if we're going to reach some kind of conclusion, we need the help of LCB on this, on drafting.
Actually, my first job was legislative counsel, so I have no problems with drafting it. Two, I have the answer with respect to whether or not if somebody's suspended or disciplined, whether they can get insurance. And actually went through and with regard to found disciplined lawyers who were opposing this, who actually have malpractice insurance. So they were severely disciplined and they had malpractice insurance. Everyone in Idaho, if they have disciplinary problems, they're able to get insurance. You can find insurance, but they need a little bit more costly. But to be uninsurable is a really dire situation very rare. So I can only say that with respect, I can affirmatively say that I can give names that the persons that have disbarment period with regard to suspensions, and they are currently insured.
I guess, Chief, to that point, I would be requesting, and I appreciate the point, and Mr. Leverty's experience in the insurance area is well known, and I respect him immensely on this point. But given the gravity of the issues, there's a number of questions here I raised, the answers to which I think can only come from the insurance companies themselves. And that's what I'm soliciting as part of my request, Chief. So maybe it would be useful to the folks who are talking about this if we cataloged some of the questions from this hearing and asked folks to supplement their responses. There's been a suggestion about rewriting the rule. There's been a number of other questions we've posed, all of which I think would provide a lot of improvement to the overall objective here. I do want to make a general comment with regard to the economics. One thing that hasn't been highlighted as much in this hearing, but we have seen an awful lot, especially over the last decade, of lawyers who have been disciplined, and disciplined for the theft or appropriation of hundreds of thousands of dollars. And in many of those instances, those disciplines resulted in requirements to pay restitution, which was an idle promise, due in large part because there was no source to pay them. I think the folks who serve on the Client Security Fund have witnessed firsthand the number of people who go uncompensated because the issue isn't within the scope of that fund. So I think this is the economics of this issue in this state demand a careful examination of alternatives.
Along with that line, I wanted to also ask Gene this question about somebody who had insurance for a number of years, had a couple claims, they were paid by the insurance company, and now they're without insurance because they chose not to renew policies, whatever, or they were not renewed. How does that affect somebody who's with mandatory insurance? In other words, you had insurance, you had some malpractice claims, and now you're being told you have to have insurance again. Is that, I understand what Justice Hardesty raised about the discipline, but what about malpractice cases where there was actually recovery by an injured party to an insurance policy, and now that person decided after a few years of practice, I don't want to have any more insurance?
Actually, I cannot point to any examples one way or the other. We'd like to know that, yes.
We can't hear in Las Vegas.
Gene, why don't you come up here?
The answer is I don't have the answer, and I don't know if it's available. The only way we do it is to contact all those that are uninsured and ask if any of them were canceled and were unable to find and get new coverage. It's my experience and my belief that even if you get canceled by one carrier, because we've all experienced a cancellation with regard to coverage, you go out and can find other coverage. And especially you start afresh because you have no prior acts coverage. So you start, if you want tail coverage or prior acts, that's going to cost you more. But you're insured to that point. So the answer is I can't point one way or the other.
Well, I think what Justice Hardesty raised about we'd send insurance people to come forward and answer his questions and some of the questions I have or my other colleagues have.
And that's what I was going to say also to Justice Hardesty's questions. We have available insurance people that we're going to get the responses to your questions. So that's what we will do. We've met with the carriers before, and we'll be with them again.
Yeah, there's a tag along.
To be clear, the malpractice insurance is not going to cover theft.
Absolutely.
I mean, this is not surety insurance.
You're absolutely right. It does not. That's why we have the Client Security Fund.
But they never can pay 100%. That's the problem. People they get pennies on the dollar sometimes.
It is a major problem. Other states have higher amounts that they pay on Client Security Fund. We've increased it over the years since we started. And it could be, New Jersey and other states have unlimited amounts with regard to, but they have to raise funds. But yes, it does not cover intentional theft. The problems that we see with regard to taking monies from trust accounts is not covered by a malpractice policy. It's an intentional act.
Yeah.
Anything additional, Mr. Levy?
Thank you.
No, that's all right. Mr. Powers?
Thank you, Your Honor. Just to follow up quickly, I think from a procedural standpoint, it might be advisable for the court to enter another order directing the State Bar to produce a redrafted provision or proposal by a date certain, and then the court could reopen the period for public comment and also direct the State Bar to answer the questions raised by the court today.
That's a very good statement. Part of my direction was trying to see what other questions we might have so that the State Bar could massage it as to some of those concerns we have, opposed to trying to do it on its own without some direction.
And then during that period, obviously, I will make myself available to the State Bar to work with them on redrafting the proposed amendment. Thank you.
Thank you very much. Mr. Eglert, you have something? Yes.
I wanted to address something that was brought up by my colleague, Mr. Ravenholt, in Las Vegas. Because I looked into this, and I think it was in the open letter that I sent all of you last year, this idea of the legislature handling this. That would be a violation of the separation of powers. It would be unconstitutional for the legislature to do that. I think I've proved that in the letter to you. I've researched this, and that's a concern other states have had by doing this through their legislature, that And you look at our rules, the Supreme Court is who governs completely the practice of law in the state of Nevada and all regulations. So I don't think the legislature would have authority to do this.
There is a concern about inviting the fox into the hen house. With that, court will take this under advisement at this time. We will issue another order as to the next step to be taken, whether additional questions, redrafting. And with that, we will stand